First one, about the crime scene. He wanted to go when they were working, which is unheard of. Judge said no. Then when they were almost done, he said, I don't want to go anymore, I don't need to go anymore. Then I guess he changed his mind after that and decided to try to go there, and the owner won't get back to him, and he doesn't want to go on the property because there are no trespassing signs everywhere. What do you make of this, yes, I do, no, I don't, yes, I do, no, I don't, and now he's like taking time in court to deal with it?
Well, it's very confusing, except if you go to the basics, which is what possible evidentiary value can it have for the defense to visit this crime scene? The crime scene has been processed. It has been compromised through the processing. It has been compromised by the fact that God knows only who has been onto that property. Nothing that can come from that area now could come into evidence because you would object, saying the integrity of the crime scene, the integrity of this evidence cannot be shown, therefore it shouldn't be admitted.
So either way, either side, if either side, the other, no matter which side would try to enter something from that area now, the other would have that argument. So you're saying what's the point?
I cannot understand. It defies logic that we keep making the same motion over and over and over again. That ship has sailed. The minute that crime scene was processed, the evidentiary value of visiting that scene ends, period.
That's great. Okay, next one. Next question is about the EquiSearch records. I don't know if they're going to fight it or not. I understood that they didn't hand them over voluntarily at the very least because he doesn't have them yet. Why do you think the defense wants them, and do you think if they do get those records, is it going to accomplish what they hope?
One, I think the defense wants those records to show the following. EquiSearch thoroughly searched that area while my client was at liberty, no body. My client gets arrested and is incarcerated. Lo and behold, body discovered after her arrest. What does that say? She's not the killer. The killer is someone else, and the killer dumped the body at that scene once my client was incarcerated.
But the other, I guess the risk in that is that he said himself, Tim Miller said himself on, I heard it, I think it was on Nancy Grace, that he was about to search that area, but there was too much water at the time he was there and didn't want to disturb whatever might have been underwater that they couldn't see. So he's already said that. If in fact they find that to be the case, they're just grasping at straws?
Well, absolutely. If Tim Miller says, look, we were not able to search because there was high water there, that answers that question. But even beyond that, this again dramatizes the significance of the forensic evidence gathered at that crime scene that connects Casey Anthony with the crime scene, alleviating or eliminating any other person as being associated with that crime scene.
In other words, are you telling me that you believe this is a signal that the defense knows there's strong evidence that links Casey to that crime scene, and so they're just going to try to attack everything they can because they obviously know there's something there that they're worried about, so they're going after every single...
The defense in this case has to attack every piece of evidence from the beginning that the state is going to offer. They have to punch holes in it. They have to create a reasonable doubt. They have to attack the forensics. They have to attack everything. They have to do what criminal defense lawyers are born to bred to do, which is attack and destroy and raise the reasonable doubt.
You think it's going to happen?
No.
Why?
Because the evidence that we have coupled with what we believe the forensics has yielded from the crime scene is going to eliminate every possible explanation of innocence and be consistent with that of guilt, excluding reasonable doubt, period.
Do you think that the fact that when he does go after everything, when he is looking for Zenaida, when he is looking for Ricky Morales' computer records, that if he is looking to make sure Jesse Grund is not the father of Kaylee, and he's going after this, do you think that it almost hurts him to do that when you say that that's what he has to do? It's almost like, well, what are you saying, that Jesse, Ricky, and Zenaida all did this together somehow, and that Casey didn't know that there was a dead body in her trunk? Like, isn't it not going to ring true, and isn't it going to be confusing to people, and aren't jurors going to be able to see through that?
Well, Kathy, you said at the last part of your question the magic word, jurors. Jurors are not going to know 99% of what happened in preparation for defense in this trial, period. And Baez has an obligation, like any criminal defense attorney would do. You open 1,000 oysters and hope that you can discover that one pearl. And so is he doing his job in that regard? Yes, he is. You cannot just assume away any potential defense that you may have in this case. So open 1,000 oysters, and by gosh, maybe you'll get one pearl.
And then by the time he goes to trial, the jurors will only hear about the one pearl.
That's absolutely right. You don't hear about the 999 oysters you opened up, and there was just an oyster there.
One other question. The whole issue of the defense asking the judge to take the prosecutors off the case. What do you make of that? They might hear that tomorrow, we're not sure.
That is a motion that is going to test the limits of the patience of this trial judge. That motion is completely without precedent, completely without merit, and we're just going to see how patient Judge Strickland is as to how much argument he's going to hear on this, and whether at some point he's going to say, you know what, there's something called a good faith pleading requirement in this case, and I want to start seeing that. But as far as taking the state off this case, let me put it simply, ain't ever going to happen, period.
Let me ask you this, just for conversation. He ordered that Casey Anthony has to be there for all the hearings, as he said before. What do you make of that? Why? Because I know that defendants have the right not to show up for court, but why in this case would he go the extra mile?
This judge is very mindful that a conviction in this case is only round one. There's going to be appellate issues, and then there's following the appellate issues. If you're not successful in arguing those, then there's going to be competency counsel. He wants to make sure that they cannot raise as an issue that had she really known what the hearing was about, or had she been informed, she would have been there, and her failure to be there, in effect, denied her some Sixth Amendment due process right.
So you understand why he's doing that?
Absolutely. I would absolutely do the same thing. She would be at each and every hearing, except possibly a pretrial conference.
I think that's what he did say. That was the exception.
Yeah. I'm going to err on the side of caution. They're not going to reverse this judge for making her appear at every hearing. They could reverse the judge if he lets her wiggle out of attendance of any of the hearings.
Right.